And we're live.
Great. Good afternoon, everyone. I want to welcome you to the meeting of the Task Force to Study Crimes, Classification, and Penalties. I'm State Senator Mary Washington. I'm honored to act as chair. I want to welcome everyone. I'm going to keep my opening comments brief, but many as you know, I do represent the 43rd District in Baltimore City. But for those of you who are joining us online, welcome to our first and only meeting that we've held this year for the Task Force to Study Crime Classifications and Penalties. Due to COVID-19 pandemic, the task force has not been able to meet, but we're all excited to be back and doing the very important work. We have been talking amongst ourselves and doing independent work along, and that's some of what you're going to see today. The duty of this task force is to examine current criminal statutes, their classification, and associated penalties. This important task force challenges us to examine the definition of crimes rather than just who commits them. And it's an important first step to bringing equitable treatment to all members of our society and members of our bodies that directly influence the system, where we're all here to do the good work. We're making sure that we know our current criminal justice system does have inequities that kind of stain from inherent structural racism or some of the criminalization of poverty. And there are times when penalties sometimes further these systematic barriers. And although this is not the specific work of this task force is charged with, we know and understand the reality that making sure that we have an objective classification system, again, the current classification system is helping us move forward with our agenda across the state of Maryland for a fair and equitable session. In our meeting, we're going to do the following. We're going to have an overview of the work completed by the chair and some committee members during the interim, a review of the recent work by organizations focusing on criminal justice reform, a discussion of some of the research findings by one of our members, Professor James Jaros, as well as the National Council for State Legislatures. We will conclude, and we'll also hear from our Justice Reinvestment Act member, Judge Long. We will conclude by considering some recommendations, and the primary recommendation will be to consider extending the term of our work in light of the fact that the pandemic has shortened our ability to succeed its duties. Next, I'm just going to ask members of the committee to introduce themselves. I'm going to start with the Senator Senator Huff.
I think Senator Huff stepped away for one moment.
Oh, he stepped away for 1 minute. So we will we'll jump.
I can go first if you'd like. Well, thank you, first of all, to Chair Washington for chairing this important task force. I really appreciate all the leadership you've shown. My name is Jeff Waldstreicher. I represent the 18th Legislative District in Montgomery County. Thank you all for serving on this important task force. And let me also thank Senator Huff, who stepped away, to congratulate him first on his elevation as Minority Whip. Senator Huff on the Senate side was the sponsor of this legislation, and I also appreciate all he has brought so far and will continue to bring. So thank you, Chair Washington, for having me.
Absolutely. And the House sponsor, Delegate Cox, would you start?
Well, good afternoon, everyone. It's an honor to be here and to see everyone again. It's been a while. I represent Frederick and Carroll counties. And I was the House sponsor along with some wonderful people on the Senate side and as well on the House side. And it's a great honor to see such a great panel here today. Looking forward to hearing the different presentations, and it's great to be here. Good to see everyone.
Great. Delegate Shetty.
Hi, thank you, Chair Washington. Hello, everyone. I'm Delegate Emily Shetty. I represent District 18 along with Senator Waldstreicher, and I'm honored to be here. I serve on the House Judiciary Committee along with Delegate Cox, and I'm grateful to have the opportunity to hear the work that's been going on and ask some questions. Thank you so much.
Great, great. Judge Long.
Thank you, Madam Chair. My name is Danny Long. I'm a retired circuit court judge from Somerset County, retired in 2016. Currently sit as a senior judge. I'm not here representing the judiciary, however. The statute requires participation by certain individuals and certain representatives of certain groups. I'm here as the chair of the Justice Reinvestment Oversight Board. And Senator Washington has asked me to give you just a brief update of some of the work that we've been doing and some of the work we're going to be doing going forward. So it's my pleasure to be here. Thank you, Senator.
Great. Professor Jaros.
Thank you. My name is Dave Jaros. I teach at the University of Baltimore School of Law. I don't actually represent anyone, and I'm tenured, so I don't have to answer to anyone. But I teach criminal law, I teach evidence and criminal procedure, and hopefully I can bring some of that expertise to the task force.
Great. Mr. Schellenberger.
Senator Washington, thank you so much. Good afternoon, all. My name is Scott Schellenberger. I'm the state's attorney in Baltimore County. I am here representing the Maryland State's Attorneys Association, and I think my appointment to this task force has broken some type of record because I might be on every one of them that's going on in the state. Professor Jaros, I'm very concerned. Doesn't look like your students are as interested as they used to be in your subjects.
Actually, this is pretty much par for the course.
Okay. Good to see you.
Great. Mr. Soul, I believe.
Soule. That's okay.
Soule, sorry.
That's okay. That's all right. Well, good afternoon, everyone. Senator Washington, appreciate it. My name is David Soule. I am the executive director for the Maryland State Commission on Criminal Sentencing Policy.
Great. And I think I've are there any, there we go. Good. Yes, please introduce yourself, Hannibal.
Hi, I'm Hannibal Kemmer with the Office of Attorney General. Thank you so much, Chair Washington. Glad to be here.
Okay, is anybody else hidden members that I don't see? Okay, I think we're great. Well,
Rachel Kamen's here from OPD.
oh, there you go. Thanks. Rachel.
Hello, Rachel Kamens from the Office of the Public Defender. I'm very happy to be here. And thank you, Senator Washington.
Excellent. Thank you. All righty. Now I think we're good. Thank you. Which is why I talked about needing that double screen. So we're going to start. Each segment would be about 15, 25 minutes. And as I said, we're going to start off. Oh, our panelists. I'll introduce the panelists as we go along. Just I mentioned we are joined by Tara Huffman with Open Society, also Iman Friedman and Samantha Blue, representing People's Commission to Decriminalize Maryland, in addition to the other presentations that we're having. Welcome and thank you for being here, and thank all of you who are watching. Professor Jaros, please, let's get started.
I'm going to share my screen here. Thank you. And let me just, there we go. Sorry. All right. Senator Washington asked if I would present some of the work that we've been doing and some of the research. And I will try to be quick. I know I have 15 minutes or less, I was told. So I'm going to talk fast, which annoys my students, but hopefully we can get through everything. Just to remind everybody, we have House Bill 542. It set forth 11 different things we were supposed to cover as part of this task force. And what I'm going to talk about today are the three boring ones. The part where we reviewed and studied both what's going on in Maryland, our history, how we got here, and how we compare to the rest of the country. And sort of the good stuff is where we talk about the recommendations we want to do going forward. And that's sort of what we're building on with this kind of foundation. Okay, so I'm going to walk through some of the things we've learned as we've tried to fulfill the first three mandates from the House bill. So the first thing we were supposed to look at was we had to review the penalties for all criminal and civil violations throughout the Maryland Code. Fortunately, we had Dr. Soule give us a presentation, but there are approximately 1,491 separate criminal offenses in Maryland, making this an extremely daunting task. We talked a little bit about this at our earlier meeting, but just to go over it, there are two types of crimes in Maryland. There are codified crimes, which have been set forth in statutes, and there are common law crimes. Codified crimes have criminal penalties which have been established by the statute that sets it forth. So for example, we have reckless endangerment. That says right in the statute, this is a misdemeanor and the maximum sentence is 5 years. It's worth noting that Maryland, unlike a lot of other places, doesn't always lay out the elements of the crimes. Instead, it relies on common law, judicial decisions to give the actual elements of the crimes. But the penalties, which is what we're focused on for this task force, are determined by statute, right? Then we have common law crimes in Maryland. These are crimes which are not laid down in the books, but are simply adopted from historical England from 1066 and on. These have no prescribed maximum. They are limited only by the 8th Amendment limitation on cruel and unusual punishment. One example of that is we have a crime for hindering a police officer. It is a common law misdemeanor with a maximum of life imprisonment. So we don't have a limitation on that penalty, okay? Now, some issues we will want to consider as we go forth throughout our work is one, we need to decide what an effective, one, is that an effective review of the penalties for these crimes and violations involves more than just knowing what the lawful range is, but how they're actually applied in practice. Second, we have to understand that the direct penalty imposed by sentencing, in addition to that, many criminal convictions carry a subsequent collateral consequences, which is a secondary penalty, which is not explicitly designed as punishment, but can have an enormous impact on the lives of the people who are convicted. And that's everything from the ability to possess a gun to the ability to get in certain kind of work licenses, to work as a security guard, or any number of other things. All right. And finally, there is a growing body of scholarship that I hope we'll be able to talk to at some point that suggests the high fiscal costs of long sentences are not balanced by significant public safety benefits. All right. Defendants age out of the criminal justice system. The severity of the of the sentence has been shown to have a very limited deterrent effect. Much more important is the certainty of whether or not someone will be caught. And there's a question about whether or not resources are better used in other areas to preserve public safety and the well-being of Maryland constituents. And I'm noting that I don't always see here, I've got my participant thing up, but I don't always see a blue hand go up. So if someone has a question or a comment, just interrupt me and we can have that conversation. To keep going, as we look forward, it's clear to me, having reviewed all of this stuff, that there are some huge holes in what we need to learn. We need to hear from the public. We need to hear from defense attorneys and prosecutors and judges who are working within the system about how their views on Maryland's criminal penalties, whether current sentencing ranges and classifications are appropriate, whether the current penalty structure is a hindrance to the effective administration of justice, or, and I think we should keep this in mind, future efforts to reform the system. Part of what we're doing now by organizing the criminal code, I think will be enormously helpful in the future when we want to do other kinds of criminal justice reform. Finally, I think we need to hear from the public and from practitioners about how crime classifications, what's a felony, what's a misdemeanor, what's a civil violation, how those classifications and those penalties are impacting different Maryland communities. And I appreciate what you said, Senator Washington, about talking about structural racism and how this stuff works in a broader context. And we need to gather more data, because in addition to having looked at the 1,491 different criminal penalties, we have a host of civil violations, and there's a great deal of data and scholarship coming out about the ways fines and fees impact people's lives, and I think that's worthy of this task force taking a close look. All right, the second thing we were asked to do was to study the history and legislative intent of the classification of criminal and civil violations throughout the Maryland Code, including the constitutional implications and their collateral consequences. This was huge, and at the same time, almost impossible. You see there's a picture here of a coral reef. That's because the history of Maryland's criminal code is a history of a criminal code that has been built by accretion. And we discussed this a little bit before. It's like a coral reef in which crimes have been added on to a common law foundation and simply built up over time. It hasn't been fashioned in any kind of systematic or organized fashion. All right. Importantly among that is this concept of classifications, the idea that we have crimes that are felonies and crimes that are misdemeanors. I think most common public people presume that a felony is a serious crime and a misdemeanor is a minor crime. and that the penalties reflect that seriousness. In Maryland, that's not always the case. One example, use of an assault weapon during the commission of a crime of violence is a misdemeanor, even though the defendant is exposed to 20 years in jail. At the same time, allowing the use of a fowl to fight with another animal is a felony with a maximum of 3 years. So we may want to review and recalibrate what we mean in terms of what these terms mean and the seriousness of those crimes. And that is not to say that the use of a foul is not a serious crime, but it's interesting that that one's a misdemeanor and the use of an assault weapon in the commission of a crime of violence is a felony. I had interference with an equine and a different picture, but apparently this October, that law was changed. All right, importantly, the history of Maryland's criminal law, there have been 2 separate occasions where the General Assembly has sought to reform and organize systematically Maryland's criminal law. We talked about this a little bit at our last meeting back in 1965. There was an earlier one in 1908. Unfortunately, despite efforts to organize in the past, these efforts have led to some small legislative changes, but not to an overall systemic organization. But what that means when we ask, what is the history of Maryland's organization and classification? It's a history of failed efforts to do it, but a recognition over time that this is something that would benefit the people of Maryland, I think. All right, interrupt me if you have questions, but I'm gonna keep going. We were also asked to look, yep.
Yeah, keep going and we'll gather.
I know I'm talking fast. We were asked to look at what are the collateral consequences in Maryland. Just for members of the public who are watching, both of you, I would point out that a collateral consequence is defined as a legal penalty, disability, or disadvantage that's imposed automatically when a person is convicted of a crime, well, felony, misdemeanor, or other offense, even if it's not included in the sentence. That's how it's defined by the American Bar Association. Interestingly, the American Bar Association has admonished states to collect and set out a reference of all collateral sanctions in a single chapter. Maryland and many other states have not done that. So when we talk about collateral consequences, we're talking about wading through the entire Maryland code in all different areas, and there are literally hundreds of these. What is interesting and I think important is that in general, the vast number of collateral consequences simply say a felony or a misdemeanor conviction triggers this consequence. So it's everything. If we ultimately work on our classifications, it may well be that even if we don't eliminate all of these collateral consequences, we might be able to be much more precise about what crimes should actually trigger a collateral consequence and what shouldn't. So this is one example where perhaps working on the classification for crimes may pay dividends down the line when people want to take a closer look at how we could change the way collateral consequences are affecting Marylanders. Okay. I said that. So keeping going, we were asked to look at the constitutional implications of the classification system in Maryland. In a nutshell, I can say, and this is my brief review, nothing enormous jumps out as to the constitutional implications, but there are some impacts of changing classifications that the task force will want to keep at the forefront of its mind as we go about this work. One is that there are jurisdictional implications of changing crime classifications. So if we were to change a crime classification, it might change whether or not a case started in district court versus circuit court. And there are some implications for when, if we were to change penalties, it would change perhaps whether or not someone was entitled to a jury trial. Once we drop below a certain length of sentence, one is no longer entitled under the Constitution to a jury trial. Those are not current constitutional problems with the system as it's currently designed. It's just one of those things we're going to have to keep aware of as we change things, or if we suggest amendments to the system, it will have implications for those things down the line. Okay. All right. Item 3, which was the big one, I will say, I thought about retitling this talk as How I Spent My Summer Vacation, where I spent a lot of time looking about, we were asked to look at how the criminal classifications and penalties in Maryland compare with other states. And in doing that, we looked at the following questions. We looked at all 50 states in DC to determine the following: how each state organizes their criminal code and classifies their crimes, which states define the terms felony and misdemeanor and what those classifications are, which state codes include a default mens rea and how, and that turns out to be a rather complicated question. 4, which states include definitions for mens rea? Just a reminder, I know most of the people on this panel know, mens rea is the mental state associated with a crime, right? So whether or not you have to act intentionally or recklessly or negligently, that's the mens rea associated with the crime. 5 is which state codes include a presumption against strict liability, because that was one of the things noted in the bill. 6 is we wanted to know which state codes were influenced or shaped by the model penal code. And finally, we took a look at just a group of example crimes to get an idea of what were the kinds of penalties that were being given in other states, to see if we could try and get an idea of how punitive Maryland is compared to the other 50 states. And that turns out to be a rather complex question, and we'll talk a little bit about that. So if I can just run through these quickly, I will shut up, but feel free to interrupt. I'm going to keep going. So the question was, how does each state organize their criminal code and classify crimes? Well, 35 of the 50 states use a graded classification system. Maryland is obviously not among them. The systems vary from state to state, everything from 3 levels of felonies up to 6 levels of felonies. And I would note that the commission that was from 1965 in Maryland proposed at the time that this is what Maryland should adopt. Okay, and in all of those systems, there are criminal penalties that are associated with a grade of crime. So for example, in Alabama, you have a B felony with, I think it was a maximum of, I could get this wrong, 20 years in jail. Okay, and every B felony has that basic penalty associated with it. And then they are still subject to statutory sentencing enhancements in cases where they have those. And many states have sentencing guidelines which give recommendations for where to fall within those ranges. Okay. In terms of the definitions of felony and misdemeanor, which we see in Maryland with an example like the possession or use of an assault weapon during a crime of violence, where you can get 20 years in jail, but that is a misdemeanor in Maryland. That's not the case in most states. 38 states have a statutory definition of felony and misdemeanor. 35 of those states define a misdemeanor either directly or indirectly as less than a year of incarceration. Many times you'll see that it is defined explicitly as a felony is when you can serve your sentence in a state institution as opposed to a county jail. But when you look deeper into the statute, you learn that that means a year in jail. Okay, so the vast majority of states treat a misdemeanor as a year or less. All right. In terms of the state codes, which include a default mens rea, and here you may want to interrupt me because I'm going to act like an annoying law professor for a second, because it turns out that there are different types of default mens rea statutes, and it may be that we want to talk both with the drafters of the bill as to what was intended, but understand that this is a complicated question. And as an example, I give you a made-up crime. If there is a crime that says it is a crime to possess a knife longer than 2 inches inside a state park. All right, the first question is, this is a badly written statute. I'm sorry, members of the General Assembly, you do this all the time, but you didn't give a mens rea. It doesn't say if you have to intentionally possess the knife or recklessly possess the knife. And many people view a default mens rea statute as when the legislature fails to identify a mens rea, one is provided as a default. So it might be that a default is, if it doesn't say, the default is recklessness. So one would say, well, that means it is a crime to recklessly possess a knife longer than 2 inches inside a state park. But notice that that does not clear up all the questions, because if you are, let's say you intentionally possess the knife, you put it in your backpack, but you didn't realize it was 2 inches, or you didn't realize that you'd wandered out of the woods into a state park, would you be guilty? So a secondary question is whether or not the mens rea applies to each of the material elements of the crime. And some default mens rea statutes speak to that issue. So we have 19 states that have a default mens rea statute that simply gives a requisite mental state. So 4 states say if the crime fails to identify a mens rea, we're going to use negligently or above. 11 states use recklessly or above, 3 states use knowingly, and 1 uses willfully. Okay, now 15 states has what's called a distributive default rule, and don't get caught up in the terminology, but that says where a statute does specify a culpable mental state, such as saying it is a crime to intentionally possess a knife in a state park, then that mental state is applied to every material element of the crime. So you have to intend to have the knife, intend to have it be 2 inches long, and intend to have it be in a state park. The other way is we have pervasive default rules, and these overlap. So it's not as if these are all different states. The pervasive default rule says that every material element of the crime has to have a mens rea, but they don't have to be the same. So for example, if the crime said it is a crime to intentionally possess a knife greater than 2 inches long in a park, well, if that had a default mens rea statute that said if they don't state the mens rea, we use recklessly, then you'd have to intend to have the knife, be reckless that it was more than 2 inches, and be reckless that you were in the state park. All of this is to convey that the question of should we have a default mens rea provision in the code requires some careful thinking exactly about how it would affect the statutes. Also, we need to recognize that we currently have statutes on the books, and we may not want this to be a retroactive rule that changes all the statutes that came before, but we might want a proactive rule that says every statute passed from this day forth, we're going to apply this default rule. And that's something for the task force to think about. And I'm running out of time, so I'm going to keep going, unless there's a question about that. All right. The next question was which state codes actually include definitions for mens rea. So give us, for example, like the model penal code saying recklessness means a subjective awareness of the risk and the defendant chooses to ignore that risk. Okay. 34 states include definitions of mens rea. Notably, Maryland does not. The majority of states use intentionally, knowingly, recklessly, and negligently. 3 states use willfully, 5 states use purposively. The model penal code does 4 mental states: knowingly, recklessly, negligently, and purposely. And that's again something for the task force to consider. We were asked to consider whether or not there should be a presumption against strict liability. 14 states do have a presumption against strict liability. It is a presumption, not a ban. It just requires that the legislature be clear about that. Just like the default rule, it may well be that that is a forward-looking rule that we would not necessarily want to be retroactive. That's something for the task force to consider. As to how many state codes were directly influenced by the model penal code, a 2007 UPenn study identified 34 states which seem to have based their codes in large part based on the model penal code. Of course, we know that the model penal code has actually influenced pretty much all 50 states in one way or another. But when we consider a classification scheme, many of the state codes that are classified in the ways that we've been discussing have been strongly influenced by the model penal code. All right, finally, how do Maryland criminal penalties compare to other states? The answer there is that is incredibly complex. It is something that we need to continue to look at as we decide, if we decide to move forward and come up with some kind of organizational schemes. Some of the hard work where the rubber hits the road is, well, what does it mean to be a C felony? And what is the sentencing range for that? There is one crime that immediately jumped out as way out of kilter. Misdemeanor assault in Maryland is a glaring outlier. It has a maximum penalty of 10 years in jail. It is the most punitive misdemeanor assault charge in the entire country by 7.5 years. Massachusetts, which is the second most punitive, has a maximum of 2.5 years. The vast majority of states, a misdemeanor assault, which have the same elements as misdemeanor assault here in Maryland, it's a 1-year maximum penalty. So it is worth noting we are grossly out of step with the rest of the country on that particular crime. I hope I'm talking fast enough. That is all of what I was asked to talk about today. The good stuff, which is in part 4, is our work that is yet to come. And at that, I will stop sharing my screen.
Thank you, Professor Jaros. And I inadvertently introduced you as James. I don't know why, but it's David. David Jaros.
I think it works for me. I'm comfortable with it.
And thank you. So again, to the committee members who've participated in this research, the conversations that we had. And I want to thank again, Professor Jaros, to take this on as your sabbatical work. And really allowed us, so if the committee could give you a hand with a little clappy, but to allow this committee to continue its work despite the pandemic, and to allow us to move forward and not simply continue as maybe to kick the can down the road, to get some meaningful progress. One of the things that you highlighted was, of course, ensuring that we have other stakeholders and hearing from others. So just after we get questions from our committee and some conversations with our committee, we're going to bring that very important component to this conversation. So I don't see any blue hands up, but I can't imagine that. There we go. Hannibal, please go ahead.
Thank you, Senator, Madam Chair. So Professor Jaros, could you remind us again, what's the difference between distributive and pervasive mens rea default statutes? And do you have a preference, like a policy preference for one or the other?
So first of all, I will say those terms come from an article by a guy named Gurinda Binder, who teaches at the other UB, University of Buffalo. And I had to read his definitions like 7 times. So I get confused by them as well. And the important thing to recognize is that they are not exclusive. It's not one or the other. They sort of deal with different issues. The first question is, does every material element of a crime have some mens rea associated with it? And then the second one, so that's pervasive. Pervasive just simply says every material element of the crime has a mens rea. A distributive rule says when a crime does identify a mens rea, that mens rea is applied to every material element. So for example, if the crime said it is a crime to recklessly possess a knife in a state park, then you would say, well, we take recklessly and apply it to both possessing the knife and being in the state park. Okay. For pervasive, the scenario where it would work out differently is if you had a pervasive rule and you didn't have the distributive rule, and you had a crime that said the default when a mens rea is not established is, for example, negligence or recklessness, and the crime said it is a crime to intentionally possess a knife in a state park, then the correct mens rea would be you'd have to intentionally possess the knife, and then you'd go to the default rule, recklessly being in the state park. All that is simply to say those are the different, we just have to be cognizant that however we write the rule, it can have different implications for how the statute is ultimately read. I hope that wasn't more confusing as opposed to less.
I guess just to follow up, do you have a policy preference as to whether we adopt a default rule, and B, if we do so, at what level of mens rea? And I'm asking for your personal opinion, which you don't normally get.
I'm fine. I love giving my personal opinion. I must say that I'm a big fan of the model penal code. And so I tend to be influenced by it. The model penal code has as a default when a statute fails to identify a mens rea, that the appropriate mens rea to apply is recklessness as defined by the model penal code, which would mean that the defendant is aware of an inappropriate risk and chooses to do it anyway. So there's a subjective component in which the defendant is aware of the danger, right? Negligence under the model penal code would be a reasonable person was aware. Okay, so the person who was simply dumb and ignorant, who possessed a knife in the park, but really didn't know they weren't supposed to, even though they should have, would not be guilty under recklessness, but would be guilty under negligence. So if I were to adopt a default mens rea as a basic default, I would probably lean towards recklessness. Then the question of whether or not it should be applied to every material element, This is where we get into a sticky area, partly because when we come up with default rules, we are in essence going back and applying rules to statutes that the General Assembly has passed in the past, right? And we want to be careful about how much we are changing legislation. So one question is whether or not any default rule we proposed should be forward-looking, prospective. And essentially telling the General Assembly, everything you do from this day forth, you should be clear about what you intend, because this is the rule that will be applied if you're not clear. It's a different question about whether or not it should be retroactive. I tend to believe more often than not that every material element of the crime should have a mens rea associated with it. So I'm kind of a fan of both. If a statute specifically identifies a mens rea, apply it to every material element. If it doesn't, apply the default rule. So I'd be in favor of that.
Great, thank you. So I saw David Soule first, and then I saw Schellenberger second, and then we'll go.
Thank you, Senator Washington. Professor Jaros, thank you for the very informative presentation. I think my question is really straightforward. I was curious, you spoke to the definition for misdemeanor and felonies and noted that I think 35 states, which is what I expected, had misdemeanors less than 1 year or less. Does the model penal code speak to a definition for misdemeanor versus felony?
I should know that. And off the top of my head, so what the model penal code does not do, it does not get into sentencing. It does not, so I will have to check. In fact, I'm gonna do a quick Google on the side and see if I can get back to you. But I don't know. I will say that it is by far the most common is a year, but I'm not sure if the model penal code actually identifies that.
Okay, thank you.
Great, thank you. Scott.
Senator, thank you so much. Professor, two questions, specifically regarding this discussion of assault. When you looked at some of these other states, were there any that had 3 levels of assault, kind of your push assault, your punch a lot assault, and then obviously your serious assault of, assault with intent to murder? Did you see that?
There absolutely was. There absolutely was. What was interesting is the definition of assault 2, the misdemeanor here, tended to be the definition that was the lowest definition in other states. So take, for example, New York, it's almost identical, except that's assault 3. And then they have 2 levels above, serious physical injury, and then assault with a weapon or intent to cause, there's serious physical injury. And I think then there's like gross physical injury or something like that. That's even more. So yes, I think there is an appropriate level of serious assault. What's interesting is that Maryland seems to have clumped a lot together.
Right. I mean, the way I've always described it to people is there are assaults and then there are assaults. And in Maryland, we call it all the same thing. So,
right.
Okay.
So the question is whether or not a punch without causing serious physical injury, any kind of serious physical injury, in most states, you punch a guy in a bar and you're facing up to a year in jail, some of them up to 180 days or up to 6 months. In Maryland, technically you're facing 10 years.
Okay. And then my second question deals with this concept of what we do being prospective. If we don't address that issue, you would agree I'm going to have some serious post-conviction problems. Or would you agree?
I don't know that I would agree. In fact, we have that. I mean, we have in the federal system, we have people who are doing crimes for drugs in places where marijuana has been legalized or decriminalized, and they're still serving time. So there's not necessarily a retro. If it was a crime when you committed it, you're convicted. I don't necessarily think changing the definitions of the crime gives anyone a cause of action.
Interesting. Well, I don't want to steal Judge Long's thunder, but we are looking at the expungement statute right now and in fact discussing the expungement issue with regard to marijuana. So I'll let Judge Long do that.
And just to add on to that, I think that point is that often it's warranted that we go back and look at those cases. It's just that the fact that we need to go back is evidence that it doesn't give you a legal claim to overturn your conviction.
Okay, thank you so much.
And also, again, thank you. Again, I think it speaks to the work of this task force that, again, it looking at classifications and making sure that they are consistent in themselves, in their intent very explicitly, can begin to eliminate some of that, so that potential disparities, again, at least moving forward. Next, we're going to hear from Tara Hoffman. She's an attorney, of course. She's with OSI. And also part of the founding members of the and leaders of the People's Commission to Decriminalize Maryland. It was established to express purpose to reduce disparate impact of justice system on youth and adults. And I thought it would be very important for them to be a part of this discussion. I think we all also recognize that part of the formation of the task force and all task force and anything that we consider in the Maryland General Assembly should have the voices of impacted people at the start. And so looking forward to hearing the work that they've been doing concurrently, with our work. So Ms. Huffman, if you would please, now that we've gotten your PowerPoint started, I'd like to introduce you to the committee, and we look forward to hearing, what your research has found.
Thank you very much, Madam Chair, and thank you to the members of the task force for the invitation and opportunity to present before you today. I'm going to start my timer just so I stay on time. But just to let me just stick to the PowerPoint. That will help me do that. And so I'm not controlling it. Aman, are you controlling the PowerPoint? Because I didn't share my screen. Somebody shared their screen.
I got it.
Okay. All right. So we can go ahead and advance to the first slide. All right. So just to give a little background and context, so I don't have to read everything that is on the screen. The People's Commission is, among other things, an extension of work that many of us have been doing around policing reform. And we know that there is incredible work, sometimes controversial work, and yet incredible work going on right now about how do we improve policing in the United States of America. But if you're talking about the role of law enforcement, at some point you also have to have the conversation and in the acknowledgement that one of the reasons why we're seeing such negative encounters and at times harmful encounters between the police and citizens is because police are being asked to intervene in people's lives, people's affairs, and people's behaviors in ways that don't have anything to do with public safety. But when you look at the way the law is written and when you look at the way the law is applied, you come to find that it's more because that person is of a certain race or ethnicity, because of that person's gender or the way they express their gender, because that person is experiencing poverty in some certain way, or because of that person is experiencing some sort of disability, whether it be a behavioral disability or physical disability. So the purpose of the People's Commission, much like the task force, is to do a review of Maryland's criminal code, as well as Maryland's juvenile code, and begin to identify those offenses that are currently on the books that, because of the way they're written and because of the way they are applied, they are having a disproportionate impact on populations that are racial minorities, that are gender and gender identity minorities, that have some sort of disability, or because of their socioeconomic status. And we see our charge as identifying those offenses, making recommendations about whether they should be repealed in their entirety or whether they should be amended to reduce the focus, as well as the punitive nature of the offense. But then also, we don't want to just do that. We also want to turn around and say, and this is what should be done instead. And so if you're going to stop doing this, if we say that the role of the police should not be to enforce this, there should not be a role of the courts and corrections to do anything about this, then if there should be a response, who or what is the alternative response? And so that is the goal and the charge of the People's Commission. And I'll say one more thing before we move to the next slide, which is we see our charge where we begin. Let me put it that way. Where we are beginning, we are not beginning with what is politically feasible right now. we are beginning with a review of what is the impact that this offense is having on a particular population that is being disproportionately impacted by it, and then making the recommendation about what we think the solution is, about whether it's politically feasible, whether there's political will about this, whether we think, you know, the General Assembly is ready. That's not the calculation that we're doing at the beginning. We're doing our review, we're coming up with the recommendations, and then we deal with the political considerations after the fact. And so I want to say that up front, so people understand what our orientation is as we enter into this process. So next slide. So here is a list of the organizations that have thus far become part of the commission. The first sort of big convening, we sort of had our first interest meeting, if you will, in October of last year, October 2019. We had our first official commission meeting in January of 2020, and then the work group started doing their thing around March or April of this year. So we have been sort of in existence and sort of getting down to nitty-gritty work for about 7 or going on 8 months now. And these are the groups that more groups are joining as we go along, but these are the groups that are members of the commission and that help populate the different working groups. Next slide. So when we talk about decriminalization, when we use that word, what do we mean? So we're talking about the elimination of policies and practices that expose marginalized communities to increased justice involvement, not because of a legitimate public safety concern, but because of behaviors and conducts that arise from their status and their identity. And we also include in our definition the implementation of how those policies and practices bear out, and then also, like I said before, the solution. So what should be done instead? And so we also want to raise up recommendations about how we can address certain conduct and certain behavior without reliance on police, courts, and corrections. Next slide. So here are our priority areas, which also comprise our 5 working groups: drug policy, homelessness, poverty, sex work, and youth. The youth working group is the working group, you know, whereas these other working groups are sort of cutting up the Maryland Criminal Code, taking on different parts of the Maryland Criminal Code. The youth working group is taking on the entire juvenile code. So they've got quite a charge, but they've also got quite a group and some help. And so we're excited about the recommendations that are going to be coming out of that working group. Next slide. We call ourselves the People's Commission because, again, we wanted to make sure that we were tapping into the expertise of people who are living with the impact of these offenses every single day. And so that has been our focus. This is our first sort of, well, I would say this begins our first outreach to policymakers and state officials who are responsible for lawmaking or responsible for the institutions who enforce or have a role in enforcing these offenses. But we started with the populations and with the organizations that represent the populations who are being impacted by these laws. And so we've had regional meetings. We had practicing social distancing. We had online meetings we did one from Western Maryland, we did Eastern Shore, we did Southern Maryland, we did Central Maryland, and that inclusive of Baltimore City, to sort of introduce us and begin to gin up some interest among members of the public and among others who are sort of in this field and who also work with the populations that are being impacted by these offenses. And we also did a regional survey, which Aman may be able to speak to the results of that survey. I don't have them top of my mind, but we did a regional survey sort of asking people, tell us, what laws do you think are currently on the books that are impacted certain populations in an unfair way? And what laws would you like to see the General Assembly take a look at for either repeal or amendment? And going forward, I'll just skip ahead a little bit and say that the work groups have been doing their work, and at our request, each one of the work groups has come up with their first 5 recommendations. So we're pulling together a preliminary report that we're going to be releasing publicly in just a couple of weeks, maybe even a few days. So we've already got these top line recommendations from each of the work groups, the first 5 and so going forward, we're going to be doing what we're calling decriminalization clinics, or decrim clinics for short, where we're going to go back to the community again, and back to interested stakeholders again, to basically say, you know, this is decriminalization 101. These are the initial recommendations of the commission, and start to get people's feedback. Feedback about what they think. Are we headed in the right direction? And specifically, where do we need to put our priority, particularly in 2021 and looking at even 2022? Because this is a multi-year. The commission, whereas the task force, at least on writing, you have a sunset, and I understand that you'll be looking to extend that sunset. The commission does not have a sunset. We will be doing this work until the commission members are satisfied that the work of the commission is done, and now we're into actually putting forth all of the recommendations and trying to get the right people to move on those recommendations. Next slide. So this begins to get to some of the first 5 recommendations, up to 5, I should say, recommendations coming from each of the working groups. And like I said, these are just the first 5. None of these working groups have reviewed all parts of the criminal code that disproportionately or have a disparate impact on the population that they belong to or that they represent in some sort of advocacy or service provision capacity. But when it comes to drug policy, and for those of you who spend time in Annapolis, you've probably seen these before. And so I don't think any of these are going to be surprising, but I'd be interested, if someone says, wait a minute, that's the first time I'm hearing that one. But they include, decriminalizing drug paraphernalia, taking possession and possession with intent from a felony to a misdemeanor. And with that, seeing the penalties for that also reduced. So interestingly enough, I was sort of surprised that drug policy didn't come back and say, just decriminalize everything. But they're saying when it comes to possession and possession with intent to distribute, let's at least start with taking it from a felony to misdemeanor. And then also establishing a higher standard of proof when it comes with possession with intent to distribute. Next slide. For homelessness, a lot of repeal that the homeless community and advocates would like to see. So repeal of the failure to obey a lawful order, repeal of 4th degree burglary, amending 6403, that is wanton trespass on private property, and 11107, which is indecent exposure, to make an exception for those people who are experiencing homelessness. Removing criminal penalties for fare evasion. And then this is not for the General Assembly, but one of our focuses, as we are mainly focused on state law, we do have a particular focus on Baltimore City municipal codes, and we would like to see Baltimore City municipal codes amended to eliminate, penalties for loitering, panhandling, camping, and solicitation. And again, as with all of these working groups, the folks who sit on the working group, again, are either have experienced homelessness for themselves, they advocate on behalf of the population, or they serve the population. And so these are the things that they see. These are the offenses that they see impacting the population in a way that is inequitable, that is racialized or gendered, or that does not get us to public safety, but really just gets this population caught up in a cycle of contact with the justice system that is not helping, and that is actually hurting the individual as well as the larger community. Next slide. Poverty, revised 5201 and related laws so that electronic monitoring fees are based on a defendant's ability to pay. We know that there was bail reform a few years ago that we will admit is having some mixed results. But one of the results that we're definitely seeing, particularly in the era of COVID, as we're trying to get people out of jail and into the community where they can practice social distancing better than they can practice it in the jail, we have a lot of people who are being released to electronic monitoring, but the electronic monitoring fees are causing as much, being as much of a burden on them as a bail would have been. And so we want to see that addressed because it particularly impacts people who are living paycheck to paycheck if they have a paycheck at all. We want to make expungement more easily accessible. I heard the state's attorney say that you're already looking at how to implement expungement laws that have already been passed. Well, we want to do some more. We want to stop wealth criminal discrimination when it comes to auto insurance. You know, the more violations you have, and those violations can be tied to your socioeconomic status, which then has a impact on your auto insurance premiums. So we want to pull that apart so that poverty and your socioeconomic status cannot be exploited when it comes to auto insurance premiums. And we want to continue the work that's already been done around reforming child support. Next slide. With sex work, and I had to make sure I had all these. So 303 is human trafficking. 304 is basically making money as the result of prostitution. 306 is engaging in the very act of prostitution, and 307 is basically owning a house or some sort of property or location where prostitution is going on. The recommendation of the sex work group is that we eliminate those statutes and that we then also automatically expunge the records of those who have previously been convicted of violating these statutes. And then I think we're on the last, yes. So then youth, when it comes to, and again, the youth have a big charge because they have a whole code they still need to go through, but they've done some good work in a short period of time. And so the youth working group is recommending the elimination of status offenses, violations, and bringing children before the sins court from the juvenile causes section of the Maryland Code. Where there needs to be some sort of response to behaviors and conducts that are troubling for a young person, what we want to see is we don't want to see the response to that be a judicial or a punitive juvenile justice response. That response should live in child welfare. That response should live in behavioral health. It should not be a response that can bootstrap a child into the juvenile justice system, into detention and incarceration, into some sort of out-of-home placement that has a punitive frame to it. We also want to narrow the definition of delinquent act to focus more specifically on public safety and not focus on behaviors that young people are exhibiting because they're going through adolescence. We want to greatly expand and standardize access to community-based diversion options, and we want to prohibit the incarceration of youth for engaging in common adolescent behavior that, again, may be concerning to us as adults, but should not engender a response that can land that young person behind a locked door, especially when it's, not posing a risk to public safety. So I think that is the end of our presentation. Yes, and so we are happy. And again, Aman is the Baltimore Action Legal Team is serving as the project manager for the People's Commission. They're helping to, make sure the meetings get scheduled, but also pulling together all of the recommendations and the work of the the commission, and making sure that we're able to put that on our website and our reports in these presentations through all of our public outreach. And so she and I are both here to answer any questions that anyone may have. And again, thank you for the opportunity.
Thank you, Ms. Huffman. And I appreciate you laying out at the very beginning what your frame is, what your perspective is. And given that you, and I think it's important for our committee to hear, while it's not our task to make recommendations to specific law changes, I wanted to ask you, it's certainly how we classify and how we penalize and what indeed is a crime is very much a part of what we hope what our work is to set out. So given that, and that you've listened to sort of our overall frame, and I know you and I have had the conversation, how do you see specifically sort of what the work of the task force, what we could be doing to collaborate, or to any ideas or recommendations for framing, for schemes, for how we should go about classifying in these different areas?
So one thing that I'll say up front is the task force, and again, I appreciate Professor Gyros's sort of, this is where we are, this is what I've been able to look at thus far. The task force could adopt the position that their charge is a very technical one, right? We want to go into the statute, we want to clean it up. And we want to make sure that there's equity within the statute. So that could be one approach. The other approach that the task force could take is to start from a place of, we want our laws to be racially just and equitable through and through, all the way throughout. And so you're not just looking within the code anymore. Now you're looking to see the impact that the code and all of these offenses are having on the people of Maryland and on different populations. And I think that if you take the latter approach, I think that when you look at even the way you classify a crime, even when you speak of mens rea and how it is defined and how it gets applied to Mr. Schellenberger's, all of us know that there's assault and then there's assault. I think all of that takes on, I think you arrive at a different result if your charge is to make sure that the laws are being applied equitably to every Maryland resident, regardless of his or her status, identity, race, as opposed to making sure that technically we are sound or consistent or rational in our application. And so I think one, it begins, where are you beginning? Where are you beginning? But where does everyone think the charge of the task force is? Second to that, I think also that to the extent that the criminal code is the purpose of the criminal code to promote public safety, or is there some other purpose beyond public safety to the criminal code? Because if the charge of the criminal code is to promote public safety, again, our position and where we begin with as the People's Commission is that there are a whole lot of things on the books that are not about public safety. Maybe they're annoying, maybe the behaviors are concerning, but they're not endangering someone. And are we prepared to own that there are many parts of the criminal justice system, from police to courts to correction and everything in between, that are based in structural racism, based in structural equity. A lot of those things were put in place to act as mechanisms of social control over certain populations. And do we want to undo that? Do we want to unravel that and make sure that we truly are putting forth and enforcing offenses that are meant to make the public, everyone in the public, safer, not just a certain segment of the public safer against another segment of the public? And so, yes, and so we're prepared to put forth very specific, repeal that, amend that, reduce that, reduce that penalty, change it from a felony to a misdemeanor. But I think that all of that can live within a frame of how these things get classified.
Yeah.
And again, what we're defining as a public safety concern, and not something that actually has some other concern that doesn't have a whole lot to do with public safety.
Right. Well, I guess I would say I don't see, to the first response, I don't see the two as mutually exclusive. I know, and certainly as chair, and I know I said at the top of the meeting that we certainly need to apply and do apply race equity, sex equity, gender. We have anti-discrimination laws in as a part of our Constitution, as a part of our state. So I don't see the two as mutually exclusive. In fact, I see that we have to have that lens when doing the actual cleanup technical work. So I don't bifurcate it in that way. But I'm going to give an opportunity for others to comment or ask questions. We have about 5-10 minutes. Who want to ask a question, have a comment? Yes, Professor Jaros.
Thanks, Ms. Huffman. That I think that's extraordinary work, and I really appreciate your comments. And I would just add to that, if you look at the actual bill that established the committee, number 4, it's make recommendations regarding the current statutory scheme for criminal and civil violations throughout the Maryland Code, including these things. So I would argue that a straight legalistic reading of this of the task force mandate is relatively broad, and that to some extent one simply cannot grapple with these issues and look at penalties, because at the end of the day, we're going to have to decide whether something's a crime and what penalties associated with it, and all of the stuff that you describe, I think, is inherently has to be a part of any informed conversation about where those things should land. I did have a sort of a comment / question, which I think is important for the task force to keep in mind, which is the importance and focus on what the word decriminalization means and how it's meant in Maryland in the past. Because technically decriminalization, or one view of decriminalization, is to make it no longer a crime. So when you, for example, in Maryland, when we made possession of marijuana a civil violation, that was decriminalization, was not legalization. And I know that many of the groups that are part of the People's Commission Coalition are focused on the impact that even those civil, it's better than a crime, but those civil violations can have on the way in which the criminal justice system becomes involved in people's lives, the degree to which we are spending resources policing those communities, even for civil violations. And I would encourage in the future for us to build a greater understanding about the difference between reducing to a civil violation and the difference between simply taking it off the books. And I think it's something important to keep in mind, because in many ways we don't necessarily accomplish the taking the police out of the process of managing certain problems when we simply reduce it to a civil violation.
Great, thank you. Again, thank you, Ms. Huffman. Next, we're going to hear, and again, this is why we curated this way, Judge Long, who is chair of our Justice Reinvestment Act Oversight, Justice Reinvestment Act Oversight Commission board. So Judge Long, would you give us some update on the work that you've been doing, and also feel free, where appropriate, your thoughts to comment on the preceding two presentations that we've had.
Yeah, thank you very much, Madam Chair. Senator Washington asked me to provide a brief update to the task force on the work of the Justice Reinvestment Oversight Board. I'm pleased to do that, but I thought it might make some sense, Madam Chair, in light of the fact that not everyone may be familiar with how the Justice Reinvestment Board came about and the work that we do. So if I can, just give a little bit of background. In 2015, legislation introduced in the General Assembly that was supported by all 3 branches of the government, the leaders of all 3 branches of the government, created a Justice Reinvestment Coordinating Council, which was tasked with developing a set of recommendations to reduce Maryland's incarcerated population, control correction costs, which were soaring out of control, and reduce recidivism rates. Now, that council made recommendations that became part of comprehensive justice reform legislation that passed with overwhelming bipartisan support in the 2016 legislative session. The legislation is known as the Justice Reinvestment Act. Its purpose is to improve public safety, reduce corrections costs, reinvest savings in strategies that can decrease crime and reduce recidivism. Now, the General Assembly, I think, very wisely deferred the effective date until October of 2017 to allow the various agencies and departments of government to gear up for implementation. Now, the act created a Justice Reinvestment Oversight Board consisting of 25 members representing various branches, agencies, and departments of state government. Delegate Kathleen DeMay represents the House of Delegates, and Senator Huff, who is, of course, on this task force, represents the Senate. Chief Judge of the District Court, John Morrissey, serves on the board, as does Judge Kathy Cox from Baltimore County. Judge Cox is at least for a few more months, is the administrative judge of the Circuit Court for Baltimore County. There are cabinet secretaries, representatives of local detention centers, local health departments, and others, including Paul DeWolf, who's the public defender, and our own Scott Schellenberger, who, as he indicates, is on just about every board, commission, task force on God's green earth. Our primary focus is to do just what our title suggests, and that is to provide oversight on the implementation of the act. We're required to meet 4 times a year. That's going to be a challenge this year, obviously, because of the pandemic. Actually, our last 2 meetings were done virtually, and they went pretty well, I think. But at our meetings, we hear briefings from the judiciary, we hear from the health department, and we hear from other agencies as to what they are doing to comply with the provisions of the act. But most recently, we become a bit more proactive, and I listened to the comments from the other presenters. Now, we don't introduce legislation, but we do make recommendations to the governor and to the General Assembly that could trigger, and has in the past triggered, legislative or regulatory action. Our focus is in 4 areas, and I've heard some of that today as well: diversion and deflection, rehabilitation, reentry and restorative justice, which can include issues regarding restitution. In 2019, as a result of recommendations of a work group that we put together, we made recommendations to expand access to geriatric role. Delegate DeMay introduced legislation last year that did not pass, in large part, I suspect, because of the shortened legislative session that we all saw. This year, our focus has been, with so many others, trying to understand the impact of the pandemic on our justice system. And we're also looking at the facilitation of communication and coordination regarding victim restitution and expungements. We put together a work group regarding restitution issues, and the members have just begun to meet, and we anticipate they will continue to meet throughout 2021. They will look at and identify a range of potential solutions, from expanding payment options, improving training, and among other things, look to additional social services support. What's interesting is the work group has reached out to the Council of State Governments Justice Restitution Resource Center for technical assistance, and we're looking forward to that assistance. If anyone's interested, the work group's next meeting is tomorrow at 1 o'clock. If there's an interest in following their work. Ms. Huffman talked about expungement. We also created very recently an expungement work group, on which there is a diverse group of stakeholders representing prosecutors, judges, justice reform advocates, and victims. Scott Schellenberger serves on that work group, as does Senator Huff. The expungement of criminal records as appropriate is an important part of the reentry process. And expungement can remove some of the barriers that prevent individuals from obtaining meaningful employment or licensing. But of course, there's always a challenge of balancing the removal of those barriers with consideration for the safety and concerns of victims of crime. And Madam Chair, we talked about this last week. At some point, I would think that the work of this group would and could dovetail with the work of this task force, as crime classification could have some impact on the expungement process. Now, this work group is just getting started, and clearly there is, as I've indicated, very much to consider. The next meeting is December the 3rd at 4 o'clock. And its work likely will also continue into 2021. And perhaps when the work group is a bit further along in its deliberations, we could offer a more extensive briefing to this task force. Madam Chair, that's all I have. Gave me 10 minutes, I think. Our next meeting of the Oversight Board is January the 7th, tentatively January the 7th at 1 o'clock. Our meetings are live streamed and the recordings constitute our minutes, and all of our meetings and reports are online and they can be accessed on the website of what used to be known as the Governor's Office of Crime Control and Prevention. But now that they have a broader responsibility, it's known as, and I had to write this down so I could get it right, the Governor's Office of Crime Prevention, Youth and Victim Services. Now, the Director of Justice Reinvestment is Daniel Asmon. He is my brains, if you will. It's A-T-Z-M-O-N. And we had a conversation yesterday, and he and I would invite you to contact him with any questions or requests for any further information. And his email address is daniel.asmon, A-T-Z-M-O-N, @maryland.gov. Madam Chair, that's all I have. I certainly would defer to Mr. Schellenberger and Senator Huff if they have any other comments that they would wish to make.
Thank you. Is that the case? Any other members of the Oversight Board want to comment or add to Judge Long's very on point and timely update?
Judge Long always does a great job, so I have nothing further to add.
Okay, thank you. And again, people who are watching, committee members, because there's been a delay in what, is moving forward our work, the purpose of this is really, again, to lay the context in which we're operating. You can see, I hope you can see that we intersect with so much that this is not simply an academic technical enterprise, that it is fundamental to the work that the state of Maryland is doing around justice reform and police reform and criminal justice reform. So to give us another context, sort of center us back to our tasks around looking at national classification systems and best practices across the country, we are looking forward to a presentation from Amanda Essex of the National Council of State Legislators. Thank you, Ms. Essex, for joining us today. And hopefully next time you come, you can actually come in person and see our great state of Maryland.
Well, good afternoon, and thank you, Madam Chair and members of the task force. Let me go ahead and get my slides up for you here. There we go. I think that looks good. So as you mentioned, my name is Amanda Essex, and I'm a senior policy specialist in the criminal justice program at the National Conference of State Legislatures. And thank you for having me join you virtually today. And I do hope to make it out to Maryland sometime. For those who are not aware of NCSL, we are a nonprofit and bipartisan organization. We serve all 50 state legislatures, the Commonwealths and territories, and we provide information and research on a wide range of policy issues, including sentencing and corrections. I'm going to start today with a brief overview of state sentencing systems, and then I'll focus in on how and why states have revised their criminal codes in recent years. So the goals of every state sentencing and corrections policies are to hold people accountable and to protect public safety. Every state has established a criminal code and a sentencing system, and that's about where the similarities end. Every state, territory, and the federal system is unique. So in general, criminal codes define what constitutes a crime, and they outline the punishments allowed for that crime. Many states have general offense classifications according to severity. So maybe it's ABC, it might be 1, 2, 3. And where crime is punished does have fiscal implications. So felony prison sentences are the state responsibility, whereas misdemeanors in most states result in local control and local costs. And in recent years, most of the changes that we've seen have been to property and drug crimes. So state sentencing systems guide the courts, the parole boards, and correction agencies on the amount and kind of punishments. They vary in the discretion given to courts and the parole boards for sentences ordered and for the time served in prisons. And while there's no universal definition, most states are primarily either indeterminate or determinate. So Maryland and the other blue states on this map, of which there are 33, have an indeterminate system, where the legislatures can assign a wide range, and then courts have broad discretion to impose prison or community supervision sentences and to determine the length of those sentences. Judges can order highly individualized sentences, and then parole boards decide when an individual can be safely released. The red, or I guess pink states here, have determinant systems, which have fixed sentence lengths. And the sentence usually includes a prison term. Often it will include a separate term for post-release supervision. And time served is determined by the court, not by the parole board, and there is no discretionary release. The rationale behind these systems were to move to an increased certainty in the time served and to reduce disparities. About half the states also have a structured component. So those are the states on here that have the circles, which includes Maryland. And this provides guidance to judges within the broad range. This is done in both determinant and determinant states in order to increase certainty and consistency. So clear example here, like you have in Maryland, are sentencing guidelines. Typically they're administratively created, sometimes they're codified, and they can be advisory or mandatory. So the states on this map in dark blue are the ones that have systems most similar to Maryland's. A handful of states have undertaken broad criminal code revisions in recent years. Some of those states to do so include Hawaii, Illinois, Indiana, and Missouri. You can see we've got Maryland on here as you are have that work underway. Hawaii had requested a committee to review and recommend revisions to the state's penal code, and the next legislative session, those changes were implemented. Illinois formed the Criminal Law Edit, Alignment, and Reform, or CLEAR Commission, which did their work over a number of years. And similarly, Indiana's Criminal Code Committee met over the course of 4 years. Many of the major reforms that I'm going to touch on today have included notable revisions to their crime categories and authorized penalties. I'm going to conclude today with breaking down those changes into 4 strategies. And many of the states have used more than one. They often go hand in hand. And the examples I'm providing today are actually from states that have not done the full criminal code revisions. So as I've mentioned, theft and drug crimes have been by far the most commonly addressed by states. In the last 10 years, a majority of states have increased the dollar threshold for theft offenses, and states have really done this to modernize the law and to keep up with the rate of inflation. Since 2011, more than 1/3 of states have amended drug penalty thresholds, generally by increasing the amount of drugs that qualify for each penalty range. They've also redefined what constitutes offenses like possession and dealing. And the goal here has really been to differentiate between people with substance use disorders and people who are high-level dealers. Arkansas and Kentucky were 2 of the first states to clearly indicate this was their intent for changes. Arkansas created 3 separate crimes: possession with intent to deliver, drug delivery, and drug manufacture, with felony categories increasing as the severity increases. The law also created an exception for people who were in possession of drug amounts considered for personal use only, and that made them eligible to have their sentence downgraded by 1 category. Kentucky wanted to give judges the option of treatment-based sentencing, and they did this by inserting weight thresholds for trafficking offenses and placing some of the lower categories of trafficking into crime categories eligible for alternative sentences. And I'll note there, Kentucky essentially just has 2 categories for drug crimes. It's either possession or trafficking. An example outside of drug and theft crimes is South Carolina's redefinition of assault and battery offenses in 2010. The state had a number of crimes classified as assault and battery, and many of them were specialized offenses like assault and battery against a sports official. They also didn't clearly distinguish some from one another. So for example, they had assault and battery with intent to kill, and they also had assault with intent to kill. So lawmakers consolidated the offenses with clear definitions of each. And this came through a major revision of their criminal code. The goal there was to provide consistency in crime classifications, to provide proportional punishments for the illegal acts, and to focus prison space on individuals who committed violent crimes. Since that 2010 law, the number of violent offenders in prison in South Carolina has gone up by 5%, but the overall prison population has actually gone down 12%. Creating degrees of crimes with penalties increasing for more serious offenses has also been a common strategy in states. I've talked about drug weights and theft dollar amounts, but states have graduated the penalties for other crimes as well. Georgia, for instance, graduated the penalties for burglary, creating two categories of crimes. One is for the buildings intended for residential use, and the other is for those not intended for residential. And they also increased the penalties for repeat offenders if they committed a similar crime. Mississippi lawmakers graduated the penalties for a number of offenses in order to clearly distinguish the seriousness of various criminal acts. And part of that graduation included pulling out some top tier offenses into new crimes, for instance, drug trafficking and criminal enterprise. One significant trend in sentencing reform is the reclassification of certain offenses, including decriminalization. The clearest example that comes to mind for many is the decriminalization of marijuana, which generally means that certain small personal consumption amounts are civil or local infraction rather than a state crime, or they're the lowest misdemeanor with no possibility of jail time. Prior to the 2020 election, 27 states and Washington, D.C. had decriminalized possession of small amounts of marijuana, and that includes the states that had legalized possession. A handful of states have also enacted laws reducing non-marijuana personal possession penalties from felonies down to misdemeanors, known as defelonization. In recent years, California, Michigan, Nevada, and Utah have looked at decriminalizing their traffic violations. It should be noted that some traffic violations, such as driving under the influence, remain criminal offenses, even when states make these changes. On the flip side, many states have designated some of the most serious nonviolent offenses as top tier crimes. Mississippi's trafficking crime targets high-level drug dealers for increased penalties, and the criminal enterprise statute targets organized retail theft. These top tier crimes were defined by high weight and high dollar amounts. Other states have targeted criminals who provide financial backing for crimes, criminal masterminds, or crimes with specialized value, such as theft of livestock or auto theft. The final way states have amended their criminal codes is by creating all new offense categories. Nebraska created a mid-level felony class 2A. Lawmakers there wanted to more uniformly group offenses by the severity of criminal conduct. So nonviolent offenses were sorted into 3 and 4, and then violent and sex offenses from those levels were bumped up to 3A and 2A. In Colorado, lawmakers created new sentencing ranges for drug crimes. And by distinguishing drug from non-drug offenses, they were able to provide judges with more alternative sentencing options, such as expedited placement in drug court and ordering a term in a drug treatment facility. One other state that I'll mention here is Alabama. They actually created a new felony class for the least serious nonviolent offenses. So rather than dropping down theft and drug penalties to misdemeanors, they created this new class with a shorter maximum punishment and more opportunity for probation. That is a quick and dirty look at other states' sentencing systems. And that concludes my remarks. Thank you again, Madam Chair, members of the task force, and I'm happy to answer questions. And I've also got my email here. You can always email me questions as well.
Thank you so much. Members, questions? Comments?
I have a question.
Absolutely.
Thank you, Ms. Essex. Thank you so much. With regard to some of the states that have concentrated on weight with regard to drugs, have any of them dealt with the relatively new phenomena of fentanyl, which only requires very small amounts to create a great deal of damage?
Yes, I do believe that fentanyl has been addressed in a number of states. I don't have that information off the top of my head, but I know we have resources that I'll be happy to send along and share with the committee.
That would be great. It's just a place we might have to carve out.
Okay. Others? Not seeing hands. Okay. All right then. It's good. Thank you, because I appreciate it. I don't know if you're willing to take a position, but from what you've been on, you've had the benefit of listening to our process, listening to some deep dive into what our task force duties are, some of the work we've done, affected communities, and then also looking at an existing effort to reform. What might you say about us? About this process? Is it important for Maryland to adjust our current classification system? What would you say? To get your feedback on what you've heard today, since we have you.
Well, as you started there, I can't necessarily take a position. I will say it was really interesting to hear Professor Jaros' presentation, because there really are some very unique elements in Maryland's code that I wasn't aware of until he gave the presentation, especially the distinction between misdemeanor and felony. I've written a brief on misdemeanor sentencing, and I had put in there that Maryland is very crime specific, but I did not realize there were misdemeanors subject to up to 10 years. So I will say it's a very unique system. And I'm happy to provide some comparative information if there are other pieces that will be useful. But unfortunately, I can't really say any more.
Of course not. Of course not. Thank you. Thank you so much for that. Okay, well then that ends our presentations and our briefing components. So Jamie, I'd like us to move into the next part, which is, I guess I could ask you actually, Amanda, you mentioned about the time period that people take, to do. I think I didn't write it down. These types of committees or task force or study group, what's the sort of average amount of time or medium amount of time that it takes to do this work?
Well, based on the states that I specifically mentioned, Hawaii looked like it actually done it fairly quickly within a legislative session. So it was a resolution in 2015 and they changed the laws in 2016, but they're actually, well, they had just introduced a resolution this last session. I didn't see if it passed, but they're looking at doing it again.
Okay.
But then Illinois, I think it was about 5 years from the time that they started to when they completed their work. And Indiana, I think, was 4 years. So some it really does take a fair amount of time to do.
Okay, great. Thank you. So now we're going to get on to our sort of voting, or just at least getting a sense of the body around 2 recommendations. So Jamie, I don't know if we've worked on some wording of it, or could you sort of jump in at this part about what's our process and how we should move forward on?
Sure. The length of the task force actually continues into the summer, or actually summer of 2021. So that does give some ability to for the General Assembly to extend its work, depending on how long you all would like to recommend that, or how long the General Assembly would like to do that, is really up to everybody here. But if there is legislation that extends it, it won't have to go through the appointments process again. The task force would still exist if it gets extended.
Great. So that would be my first sense of the body. I'd like to propose that we extend it a year. So that would give us, right now it's set to expire June of 21. Given we've lost a year, and extended just a year, and recognizing that, yeah, possibly the work could go on, but really wanting to be mindful that we accomplish something during our current tenure. And so wanting to make sure that we get the work done, that we have an opportunity to maybe do some of the stakeholder hearings and briefings, maybe some of the sort of more in-depth committee work that we've seen done by other legislatures. And so that's my first, is just to get a sense, is anyone opposes, or can we say by acclamation that we would support extending the task force?
I mean, I support that. And I was just going to add on that I would say support it for, move forward for 1 year. I'd be interested to hear from Professor Jaros how long he thinks that, because I think he really nailed what we're looking for. I mean, as far as the problems with the classifications, the problems with with crimes being lumped on top of each other. By the way, The equine, you're welcome. I fixed that one for you. That was last session. So that was one I got out of there. But I mean, your slide really nailed it as far as the disparities, the lack of mens rea on a number of these things. And maybe, I don't know if there's possible to come with something this session. I mean, the assault one was startling, quite frankly. And that is such a huge problem. I mean, I don't know if it's worth trying to do something with assault this session and do something with default mens rea, or if we all just wait until we do a report together, maybe that's the smarter way. But I'd be kind of interested to hear from the professor if we can do this if he thinks we can get this done in a year, and what resources are needed so we can do this and get it done right.
Well, as usual, I'm happy to jump in and give my opinion when it has no basis in fact.
Well, you should be a legislator then. That's what we're paid to do.
My
You resemble that remark, Senator Huff.
My instinct is to split that. The idea of considering separate legislation that would deal with the question of assault, whether there should be, as Mr. Schellenberger noted, like a 3rd degree assault. I think that actually makes sense as a separate bit of legislation if you wanted to move forward on something now. The idea that there would be a typical misdemeanor assault charge makes a lot of sense. When I think about something like establishing the default mens rea, it seems more a part of an organized system that I would rather, if it were me, do as a whole and think about how it's structured. So my immediate instinct is not to do that as a separate piece, but that's just, me answering off the cuff.
Yeah, and I would say, Senator Huff, I certainly think that maybe some of the things that we've seen and some things we could propose separately, but it's just given the fact that we've only been able to meet once as a committee, that individual members of the committee, we could certainly move forward, and I think we should, right? But in terms of what we write in our report and what our recommendations are, I'm in line with, if there are some things like extending the amount of time of the committee, I would also like us to consider adding some additional members to the committee. Again, I don't want this unwieldy 21-person committee, but there clearly are voices that should be and can be a part of this process, and frankly, that can allow us to continue to do the work.
I actually would not want that, just to be honest. I mean, when we put it together, I'd want to keep as many ideological and constituent groups and things like that, quite frankly, off, because I just wanted this to be academic. I mean, some of these things, I know once we get into testifying, people will all have their say. But the more groups we put in there that are ideological, that's why we do have on here, though, we have the state's attorneys and the public defenders. So we have different sides on the crime. But when you start bringing in groups that have their own agendas, this is really supposed to be very academic, as the professor's kind of laying out. And I would not want to add more members, is my feeling on that.
Okay, well, we can definitely, let's move forward on the one that we do have consensus, which would certainly be extending the time of the meeting, the amount of time. Is that?
Senator, I think Mr. Schellenberger has his hand up.
Oh, sorry.
Oh, I just wanted, Senator Huff, you may want to have one of your staff take a look back 2 or 3 years ago. There was a statute introduced, or a bill introduced, that broke assault up in 3 places. I have a recollection of, very similar to what the professor was talking about, a 3rd degree assault, kind of the way the burglary and B&E statute is, where you have 1, 2, and 3. There was a 3rd degree assault, which was a misdemeanor, and I think it was a less than a year in jail. And then there was our assault that we have right now, which was the 10, and then we got assault in the 1st degree, which already exists. So I think there was a bill a couple years ago, and certainly that would be something you could probably accomplish independent of the group here.
If you could find that for him, because there's going to be. I'm sorry. We'll look for it too.
He wants you to be his staff, Scott.
I have a box
He's
over
having
here
you
that
be
says,
the
let's
staff.
Raise that. I will try to find it.
I'll volunteer to see if I can take a look at it, and if it's something that I can track down and do some drafting on, I'm happy to try.
I'll take a look.
Yeah, if anyone could find it, I'll try too. But I was thinking, Scott, we're going to have the crime bill is going to be up and being discussed this session. So, quite frankly, his slide about the assault weapon felony was something that we were trying to fix last year in the crime bill. And that's a great thing to, I think, as a compromise, we can add up is we can fix.
Oh,
So anyways, it's just an idea.
Well, if you fix that one concerning the poultry, you're going to have a lot of lobbyists against you.
So members, this is great. We can continue open discussion here. Other ideas about things that you think that we could do? I mean, that's certainly the frame of adding whatever recommendations we might have to be a part of what we know as a larger package of reform. And that's certainly how I could imagine it. Maybe some of the things that were presented to us by the People's Commission, or that some of your other constituents, that we could, again, have it be part of the larger package and not specifically a bill from this group. I see Delegate Shetty is nodding her head to that. Or are you just enjoying your lunch? Okay.
Well, what does the professor need more resources, or what do we need to be successful over the next year? I guess is my question, that in order to put this report together. I mean, do we need to get DLS staff to help you, or get some law clerks, or what can we do?
I definitely think it sounds like Hawaii's been working on this, so a trip out there makes sense.
Got it.
I'm not entirely sure because, before we can get to that really complex question, there's sort of big decisions that have to be made by the task force, such as, are we going to shift to some kind of classification system, such as the one that was proposed in 1973, such as, we've been talking about. Once that happens, you can get into the sort of nitty gritty of how many classifications, where will those sentence ranges be, how do we compare them with other states? But it's hard to get going before we have some kind of direction on, are we really going this way? And I do think whether or not there are constituencies who are added to the task force, it is important to hear from those communities about just, what do we want to do? We're going to at some point have to sit down and say, a B felony falls in this range, much like it does in these other states, and match things up and decide what should be a felony, what should be a misdemeanor, what grade they should be, and what should become a civil violation. In fact, that's part of the focus of the legislation, I believe. So I have RAs right now, which is kind of awesome. And so I can rely on them until they graduate, and I'm doing my best to fail them so they can't. So I don't know if there's more resources until we have more direction about what we need to do.
Well, so I'm going to put out two things. Let's just finish that. I'm taking it that there's a yes. I don't know if you need to do individual votes, but there's a yes for the extension. Okay, so that's off the table. We passed that. So the second one, I do think we're probably ready. Should ask the question, do we want to explore, or do we feel we've learned enough to say we should have some sort of classification system in Maryland? Are we ready as a committee to say that, or still do we need to deliberate? And this generally, do we need to deliberate that, Hannibal?
So thank you, Chair Washington. I think, at some level of abstraction, I would be for a classification system. I don't know that even another year will necessarily grant us sufficient time to rewrite basically the whole criminal code. And I think that there's a portion of that has to be done to address common law crimes. So, I mean, I would be interested in what Dr. Soule thinks about this, because I think he's more grounded than I am, at least, in Maryland's statutory and common law crimes, and also might have a sense of the scope of the job if we were to try.
Yeah.
Oh, well, since I'm being asked to get time, I appreciate it. Yeah, I 100% agree. And I think we had some of these conversations at one of our meetings when we met in person last year about the common law, the classification of the common law offenses. I would definitely want to put that on the table, because I think that is an area where the commission has taken up the liberty, the Sentencing Commission, I should say, of classifying those common law offenses. But that is a task that, was somewhat difficult to do, because they, of course, don't have the statutory maximum penalty associated with them that we usually do to make comparisons. So when we're trying to compare apples to apples, it makes it hard. So I think that it would be a useful endeavor for this task force to take up that task.
Yep, but this is the open discussion. Go ahead. Go ahead, you can speak, just speak.
Yeah, so sorry.
Small enough group where we can.
Right. The other thing I would be curious about, and I don't know if my good longtime friend Tara Huffman's jumped off, but if she's still here, I mean, I would be interested in, I have no doubt that there's great utility in using a racial prism to evaluate different proposals. But I'd be interested in just some examples of the disparate impact of various laws that we have under consideration upon, communities of color, women, men, people of different socioeconomic status, because I think that will really inform and may even bring folks who are, not as inclined as I am to necessarily, acknowledge those facts if we had the data. And I think that could be really useful. And I certainly hope Decriminalize Maryland will help us in that regard. That was all.
Great.
I'll just volunteer that I have a feeling I would be able to hijack some law clerks from the public defender's office, maybe to devote to some of the labor to the extent that we can use them. I'm sure there'd be no pushback on that.
And I'll add that, as someone who practiced outside of Maryland, just to bring that perspective, Maryland system's crazy. And I strongly do favor adopting, and I think the fact is that Maryland has, blinked when it came to doing the work, but has recognized that this is a valuable thing twice before. And I think we should adopt an organized system. I think making the terms felony and misdemeanor mean something other than just that, 500 years ago, it was called a misdemeanor or a felony, either in England or for some jurisdiction reasons, we've adopted misdemeanor for possession of an assault weapon and the crime of a violent felony or violent crime. I think it makes sense for us to make those terms mean something that matches up with the public's perception of crime. I also think that it is an opportunity to look at sentencing. I think that the world has progressed considerably in terms of criminology and understanding of the impact of the criminal justice system socially. And so we will do some work, I think, on the level of punitiveness that's associated with each crime and what those penalties should be. But it does seem like we have a bit of a roadmap here. Like the first step is, do we want to move to an organized system? And I think as we start to work through where things fall, we'll start to have probably in-depth debates about where a particular crime falls within that organizational system. And I'm sure we'll have healthy disagreements about some of those things. But I imagine that the first step is recognizing that on either side, organizing it in such a way that penalties match up, that like crimes face similar penalties, that we have gradations so that future reforms are easier. You can simply say, all C felonies and above, you have a collateral consequence, D and E, you don't. Those kinds of things just make sense to me.
Mm-hmm. Senator Walsh,
can I add one thing?
Yeah,
it's not that Maryland has a crazy system. It's the crazy thing, Maryland has no system.
Yeah, I think that's right.
Senator Wallstreicher.
Well, so let me just kind of bifurcate the path forward, because I think the professor is right. And I think it's intimidating to think about doing this for all 2,000 crimes and creating this classification system and kind of the gradations that go between it. We don't have to do it all in one chunk. And what we can do first, and I think the professor is hinting at this, is better indicate what is a felony and what is a misdemeanor. And that will avoid a kind of protracted conversation about class 1 felony, class 2 felony, class 1. We can kind of bifurcate between felonies and misdemeanors and then return to that at some later point to better classify within those categories. And so that might be an easier way forward than trying to take it all as one big chunk.
Mhm. Okay. All right. So and it's also could in fact be the case that at the end of the year, I guess, again, I guess I'm inclined I'm not inclined to sort of extend something past the terms that any of us who are currently are here. Certainly I, intend to be here, but want to make sure that the work we can accomplish can happen within the course of our terms. And if it's the case, if it's the opinion of this body that the work needs to continue, we certainly could make that recommendation, and maybe there's a more formal commission in line of the oversight board, and it can be extended for 2 years. I like the idea of you say bifurcating it, of doing some work. Does anyone, any committee member feel that it's inconsistent, that is inconsistent with saying that we should develop some type of classification system? I mean, I'm trying to figure out how do we, so, what the bill, and certainly we could work offline about what that bill looks like and what the words are, but I just want to get approved in concept that we want to go forward, that we think it's a good idea to establish some type of standardization classification system. And then we can work and we can take a more formal vote if we need to find out, I don't know that we need to, about what the exact wording is. Thoughts?
It seems like you have a consensus that we want to go forward with a classification system.
Yeah.
It seems like it's like if your garage is a real mess, everyone's like, yeah, we should organize it. It just seems like in the past they've looked and they're like, oh my gosh, it's going to take, it's going to take a month, forget it. And we just pile more stuff on.
Right.
So it seems like everyone has said, and that was one of the main points of this was do a classification. So maybe we can fit in another meeting in December and we can have, I don't know, a presentation, either a path forward or how other states do classifications, and go from there.
So I love that you said that, because I didn't necessarily, we'd have to get that approved. We have to look at what's available, but at the very least, I think there could be an opportunity for those of us that want to get together to sort of finalize what this would look like, and then to put forward a vote. Jamie, again, I've done this in my joint committees. I don't know if task force are able or required to do it. Are we required to take another vote, or can we say, can you write a recommendation based on what we've said today, and given that we look at some final version later?
Sure. So I think in concept, what I would probably put together before the next meeting would be to extend the task force by 1 year, and then also a recommendation from the task force, just saying to the General Assembly that there really should be some sort of classification scheme. But right, I can put that language in front of you guys at the next meeting.
Okay, so could you look and see if there, and I'm okay with it, I'm good with it, to have a very targeted, hour, 40-minute meeting to specifically discuss the path forward and what that would look like.
Sure. I'll go ahead and email
Great.
everybody out either this evening or tomorrow with some dates, and
Very
we'll
good.
see what works.
Can
Oh, I like all of you. Good.
So
Yes.
one more thing, Senator Wallstreicher, I like his idea about kind of focusing in on either the misdemeanors or the felonies, but let's not forget, it's when you compare the two where you see the incongruity. And so that's the only thing we can't forget to compare.
No, Scott, that was my exact point, in that
Okay.
that incongruity is the first thing we can resolve, trying to normalize between felonies and misdemeanors before jumping into each category and then slicing it up into subcategories.
So to summarize, Jeff, you're basically saying, let's start off by putting misdemeanors where misdemeanors go, felonies where felonies go. And then once we like last year, we had the bill that was it drugging a racehorse or interfering with a racehorse as a felony. We just moved to a misdemeanor. So is that your suggestion, is to fix those first, put them in the correct piles, and then once we put them in the correct piles, then to make them class A, B, C, or 1, 2, 3, whatever we do?
That would be my suggestion. I don't want to speak for the group here, but that would be my suggestion. Yes, sir.
Sounds good.
So can I offer a counter to that a little bit, which may not be what the group wants to do. But to a certain extent, I think it is useful to think felonies and misdemeanors. In some ways, they're like, what do we really want to make small under a year if we choose to adopt a year, and what is big? And I don't know that that'll be that hard, but I also have a feeling that if we move closer to adopting some kind of structure, then it's going to sort of, things will start to filter out, and then we'll have the tinkering of, you know what, that's a D felony instead of an A misdemeanor. Or what does it look like in others? So I kind of favor developing some sort of structure to be able to think about these things, even if what it means to be a D felony, what the sentencing range isn't decided yet.
Yeah.
I think that might be worthwhile.
Yeah.
There are enough basic structures out there, at least, that we could start moving forward, at least simultaneously. We could start to sift felonies and misdemeanors, but also start to get a structure that we know eventually we're going to be sprinkling the crimes throughout on this. I think that makes sense.
And yeah, I like that. And to throw another wrench in just in the last minute, mens rea, is that something we also need to add in to talk about? I mean, it keeps coming up. And it seems really pretty fundamental to a classification system. Would that be something that we should? I'm just going to put that might be something we could talk about over the next year that requires.
That is a big leap. I mean, that's a lot of work.
Well, it's a discussion. We've got to start.
Okay.
I mean, we didn't say we'd solve it, but it seems like everyone keeps punting that one away. And again, I'm not an attorney, but it does seem very fundamental to whether, to how serious something is.
Well, I don't know if it's possible, but to the extent that Jamie is able to write something that essentially re-ups the mandate we have, frankly, the mandate is pretty broad, and no one's going to be able to say, well, they didn't do X or Y.
Right.
I don't know if there's any value in sort of not just extending what we have and seeing what we can do with it. I have a feeling some of these things are simply related. Where something falls in terms of how comfortable you are making it a serious felony versus a minor felony may turn a little bit on what kind of mens rea you think is associated with that crime. So these things tend to be tightly connected. And I have a feeling these challenges sort of will develop and have to be resolved as we do the work.
Sure. Okay.
I gotta bet a default mens rea is actually pretty easy to draft. It's just, as they say, the devil's in the details. But I definitely think we should look at that. And I think, Professor, you gave an excellent example of that one that people probably violate all the time when they go camping. That was a perfect example of why we need a default mens rea statute. So I think we should definitely push it forward on that.
Okay. And again, this is about the report and the writing. And so we're saying we're going to re-up, we're going to do everything, but there's also a part of it saying, well, what do we really think we'll accomplish? And I think that's what we will solidify in our next meeting. And it's more of a plan forward so that we can figure out, do we need committees? Do we need to have public meetings? I think, and having that as part of what we're saying we plan to do in the next year. And then also putting us in a position that we may need additional support to accomplish this, and then how we go about it. So we're at our end time. Thank you all so much. We will set a time for the next meeting, but it looks like we accomplished a lot in a short period of time. So again,
I found that assault law, by the way. You all are off the hook.
Oh, good. Yay.
Senator, would you mind sending that to me?
Okay, you all can continue to talk. I have another meeting as well. Thank you, everyone, for joining us, and look forward to seeing you the next time.